लिंक दिसत का नाहीये पॉलिटी 2? Hello friends, let's start with the second part of our marathon series of UPSC Prelims Indian Polity. Now we'll go for one of the most important topic which is important for UPSC Prelims in Indian Polity is amendment to the constitution. Now why this topic is important? Because a very small topic but very sure that it will definitely give you a question or a two and 2 marks definitely. So amendment to the constitution, we are not going in detail or unnecessary details of this topic, certain important part, and the most important question is being asked on the procedure. So first thing, can we amend the constitution? Yes, we can amend the constitution under article 368. Very important article. Huh? Remember, it is very important article. Amendment will be made under article 368. Which is important part? Part 20 of the Indian constitution. Why it is important? I told you in previous session that two favorite parts of UPSC. One is part 20, second is part 18. Part 18 is related with emergency provisions. Part 20 is related with amendment of the constitution. So basically part 18 and part 20 are very important parts which are related with this particular UPSC prelims. So part 18 emergency, part 20 amendment of the constitution. So here part 20 talks about amendment of the constitution. What it says, Parliament cannot amend those provisions which forms the basic structure of the Indian constitution. Keshavananda Bharati case, 24th of April 1973. So what it says very critically, very basically, it says first thing, article 368 is amendment of the constitution. Part 20 is amendment of the constitution. Can we amend entire constitution? Yes, we can amend entire constitution. But while amending the constitution, we should not violate basic structure of the Indian constitution. It means we cannot amend the entire constitution. It is reflective of the most important feature of Indian constitution, which says we have synthesis of parliamentary sovereignty and judicial supremacy. Indian parliament has the right to amend entire constitution, but whether those amendments are rightful, legal, correct, or not shall be verified by judiciary. Judiciary has the every right to nullify all unnecessary, unwarranted amendment made by parliament. That's why it says, can we amend entire constitution? Yes, it shows parliamentary sovereignty. But what we can do, we can change entire constitution without changing basic structure of Indian constitution, which is given in Keshwananda Bharati case. Who will decide basic structure? Judiciary will decide the basic structure. So it shows in India we have synthesis of parliamentary sovereignty and judicial supremacy. Clear? Now coming to the part, Indian constitution is neither flexible completely nor rigid. It is mix of both. Certain provisions can be changed very easily by simple majority, so it is flexible constitution. Certain provisions cannot be changed very easily. It requires special majority of parliament, and in few cases you require special majority of parliament along with at least half of the states saying yes by simple majority. It reflects our constitution is rigid also. So it is mix of both flexibility as well as rigidity, or synthesis of both flexibility as well as rigidity. Now, what Article 368 says? Now, this thing that I am going to explain is the most important. It is definitely going to give you +1 question. First thing, where we can introduce the amendment bill? It can be introduced in Lok Sabha or Rajya Sabha, not in state legislature. So, Article 368's introduction is a unitary feature where only central government have the right to amend the constitution. Constitutional amendment bill can be introduced either in Lok Sabha or in Rajya Sabha, but can never be introduced in state legislative assemblies. Second, who can introduce amendment bill? It can be introduced by a minister or a private member. Who is private member? Any member of Lok Sabha or Rajya Sabha who is not minister will be called as a private member. Any member of Lok Sabha or Rajya Sabha who is not a minister, irrespective of political party, will be called as a private member. For example, in the first Lok Sabha of Modi government in 2014 to 2019, Mr. Amit Shah was not a minister. He was a private member. Then he became home minister. So when a person becomes a minister, he is called as a government member. And when he is not a minister, he is called as a private member. So an amendment bill can be introduced by either a minister or a private member. It does not require prior permission of the President of India. We have seen many articles where previous permission of President is needed. This could be a potential question in UPSC Prelims, that which among the following articles require prior permission of the President of India. In that, I will tell you, one is Article 3, that is changing the name, area and boundary of a state. Second is Article 1110, that is money bill. It requires prior permission of the President of India. I will write article here. Third is Article 112, that is annual financial statement. It is about budget, but remember the word budget is not used anywhere in the constitution. We have a word which is known as annual financial statement. Then Article 304, that is imposing restriction on free trade, commerce and intercourse between the states by a state bill. It requires prior permission of the President of India. It is about trade, commerce and intercourse. And then comes Article 31 capital A. So these are 5 important instances where prior permission of the President is very, very essential. Another important provision is Article 113 that we'll discuss. Article 113 says that no demand for grant can be presented in the Parliament without prior permission of the President of India. It is demand for grant. Remember these articles where prior permission of President is very, very essential. Article 3, changing name, area and boundary of a state. 110, money bill. 112, annual financial statement. 304, a bill of state legislature which is imposing restriction on trade, commerce and intercourse amongst the state. And Article 31 capital A, making laws in 5 categories which might violate Article 49-19 that we'll discuss during fundamental right. Article 113, demand for grant. So these are the cases where prior permission of president is very, very essential. But in case of amendment bill, here it is made very, very clear. It does not require prior permission of the president of India to impose any kind of to introduce any kind of a bill. Each house must pass this amendment bill separately. There is no provision for joint sitting. There is no provision for joint sitting for amendment bill. We'll go into the brief of joint sitting, which says, see, first thing, joint sitting is introduced under Article 108. Whenever there is a deadlock between two houses, whenever there is a deadlock between two houses, in that case, we can go for a joint sitting. Joint sitting is summoned under Article 108. In the center, joint sitting is called upon, or joint sitting is summoned by President of India. Remember, joint sitting is summoned by President of India, but it is chaired by Speaker of Lok Sabha. Remember, if Speaker is not there, Deputy Speaker will be there. And if Deputy Speaker is not there, Rajya Sabha's Deputy Chairman will be there. One very important thing, Chairman of Rajya Sabha will never preside joint sitting. I repeat once again, Chairman of Rajya Sabha will never preside joint sitting. Whenever there is a deadlock between two houses, Article 108 will get activated. It is for joint sitting. Joint sitting will be summoned by President of India. It will be chaired by Speaker. If he is not there, Deputy Speaker. If he is not there, Deputy Chairman. But Chairman of Rajya Sabha will never preside joint sitting, and all the decisions shall be taken by combined voting of the Lok Sabha as well as Rajya Sabha. And this provision is added by 24th Amendment Act of 1971. President cannot withhold, no, not this one, this one. President cannot withhold his assent or not return the constitutional amendment bill for reconsideration of parliament. So whenever a bill of constitutional amendment goes to the president, he must give his assent to the amendment bill. As per 24th Amendment Act of 1971, president must give his assent. He cannot withhold the bill. Now, what are types of amendment? Amendment can be made in three simple types. One is by simple majority. But what simple majority says? It says provisions in the constitution amended by simple majority are outside the scope of Article 368. It says that when you are amending certain provisions into the constitution by simple majority, it is a first type. So they should be kept out of the scope of Article 368. Why? Because by simple majority, we make only cosmetic changes and not fundamental changes. Simple majority is not used for fundamental changes. Simple majority is used for cosmetic changes only, superficial changes only. That's why they said that those amendments to the constitution which are made by simple majority of the Indian constitution should be kept outside the scope of Article 368. What all things are included in simple majority? A very simple thing like names of state boundary, it is Article 3, then Legislative Council, second schedule, quorum, privileges of Parliament, rules of procedure in Parliament. I'll just go through. These are important. They will ask you. Use of English language, use of official language, citizenship, election to Parliament and state legislature, delimitation of constituencies. Fifth schedule is there. Then sixth schedule, union territories, more jurisdiction on Supreme Court, number of judges in the Supreme Court. All these are changed by simple majority. Now second, certain provisions are changed by special majority of the Parliament separately. Lok Sabha should give special majority separately. Rajya Sabha should give special majority separately. So special majority of Parliament separately along with consent of half of the states by simple majority. Here there is no time limit for state to give their consent to the bill. At least half of the states should say yes to this bill. Now what are the provisions of the constitution which are amended by this method? Basically, since here we are taking permission of the states, here we are thinking about provisions which are related with the state. So basically, the provisions of the constitution which are related with the states, which affect the state, which compromise the state, which gives equal power to the states, or which protect the states from the central encroachment are called as federal feature. So by this method, we amend federal features of the Indian Constitution. By second method, we change federal features of the Constitution. What are federal features? First one is election of president and its manner. Why it is federal feature? Because state legislative assembly members do take part in the elections of president. Second, extent of executive power of the union and state. Why it is federal? Because if we increase executive power of the union, it will decrease executive power of the state. Or if we increase executive power of state, it will put unnecessary burden on the state. So state must be taken into consideration. Third, Supreme Court and High Court. Basically, we have single integrated judicial system. That's why regarding Supreme Court and High Court, decision must be taken by all the states. Next one, distribution of legislative power between union and state. That is, it talks about 7th schedule. Then representation of states in parliament, and last one is article 368 itself. So if you want to make any changes in article 368 itself, you need to take permission of at least half of the states. A critical or different type of question might be asked, is article 368 a federal feature? Yes. Article 368 is a federal feature of Indian Constitution. I will star mark this point. Remember, article 368 is a federal feature of Indian Constitution. Then comes third part. What is third part? Sorry. No, this is same any of the list in the 7th schedule and goods and services tax. It comes. Then comes third type. Third type is what? It is by special majority of the parliament. That is special majority of Lok Sabha and Rajya Sabha only. We are studying here article 368, which says there are 3 types of amendments. One is by simple majority of parliament, second special majority of parliament, and third special majority of parliament plus at least half of the state saying yes by simple majority. Here one very important thing, there is no time limit within which states should say yes or no to a bill. There is no time limit within which state should say yes or no to a particular bill. Now coming to the third part, here we can amend third type. We can use this third type for fundamental right, for DPSP, and any provision which is not amended by previous 2 types. Any provision of the constitution which is not amended by simple majority or special majority plus half of the states will be amended by third type. So here scope is much vaster. Here scope is much higher. So by special majority of parliament, we amend fundamental right, we amend DPSP, we amend all the provisions which are not covered by first and second types of the amendment. Clear? So this is very clear thing. Now, we will not go into the philosophy of this part regarding amendability of the fundamental right. Simple type is there or simple question is there. Can we amend fundamental right? Yes, we can amend the fundamental right. Can we amend entire fundamental right? Yes, we can amend entire fundamental right. Then what is the restriction? While making amendments, you should not violate basic structure of Indian Constitution. It means you do not have absolute power to amend entire fundamental rights. Then what is the conclusion that we have? Can we amend fundamental right? Yes, fundamental rights can be amended, but this amendment should not violate basic structure of Indian Constitution. Clear? So this is amendability of fundamental right. A very simple part is just go through the cases. They won't ask you very difficult cases. 1 or 2 questions might be asked on cases. We are more concerned about our theory, which is very important for the examination. So this is about second topic, that is fundamental right. We will go for next topic, that is preamble of the Indian Constitution. We'll start with the preamble, a very important part, because preamble is again a very favorite part of UPSC. And another thing, Basically, while asking questions on the preamble, UPSC definitely go for certain philosophical part. Why? As we discussed, our constitution is a book. It has chapters, it has parts, subparts, schedules. Also, every book has an introduction. This introduction talks about essence of that particular book. Same, our constitution have preamble which talks about essence of the Indian constitution. So what is essence of the constitution? That we'll try to understand. So preamble, we'll try to understand certain philosophical part here, because in preamble mostly UPSC will ask you question which are philosophical, or MPSC or State Public Service Commission will go to philosophical questions regarding preamble. No, preamble embodies the basic philosophy and fundamental values. Basic philosophy and fundamental values on which this constitution is based. Preamble contains grand and noble visions of the Constituent Assembly. This could be the straightforward question for prelims. Which among the following parts embodies the grand and noble visions of the Constituent Assembly? So it is preamble. Preamble is an essence of the constitution. This word is also important. I'm not going to explain, I'm not going into the philosophy, I'm just discussing what is important for prelims. Now, from where we have taken preamble, it is based on objective resolution. Remember, objective resolution moved by Pandit Nehru. Here date is very, very important. Preamble is based on objective resolution moved by Pandit Nehru on 13th of December 1946. This date is important. This is approved on 2nd of January 1947. This date is also important. 13th of December 1946, 22nd January 1947. Now, objective resolution had this wording: sovereign, independent republic. Sovereign, independent republic. Our preamble has different wordings. It talks about sovereign, democratic republic. So we expunged this word independent. We added sovereign, democratic republic. So these were original wording: sovereign, democratic republic. Then we amended preamble and we added three important words: socialist, secular, integrity. Socialist, secular, integrity. After adding these words, we have sovereign, socialist, secular, democratic republic. Justice, liberty, equality, fraternity. Right? So these are changes very important for the prelims. American Constitution is the first in the world to begin with preamble. Remember, this is exception. Objective resolution did not have fraternity word. Again, exception. Preamble has been amended only once, that is by 42nd Amendment Act, which is known as mini constitution, and we added three important words: socialist, secular, integrity. We added these three words: socialist, secular, integrity words have been added. Now, this is very important for your prelims match the pair. Whatever copies, original copies that we have, these copies are attached with certain different very eminent names. Handwritten preamble of Indian Constitution is written by Prem Bihari Raizada. Handwritten preamble in English is by Prem Bihari Raizada. Design on preamble is provided by Biohar Ram Manohar Sinha. Handwritten preamble in Hindi is by Vasant Krishna Vaidya. These three things are very, very important. Handwritten Prem Bihari Raizada, then comes design Biohar Ram Manohar Sinha, and in Hindi it is by Vasant Krishna Vaidya. Nani Palkhiwala has called preamble as an identity card of the Indian Constitution. How to remember? Just imagine a palki where everywhere identity card have been, they are hanging. So Nani Palkhiwala called preamble as an identity card of Indian Constitution. This statement is very important for your preliminary examination. When we read preamble, we come to know four important things. Since it starts with the word "we the people of India," so it shows us what is the source of authority. Source of authority is people of India. We, the people of India, having solemnly resolved, that is, we have decided we, the people of India, we have decided to make India into a sovereign, socialist, secular, democratic republic. So when we read preamble, we come to know first thing, what is the source of authority? Second, we come to know what is the nature of state. We come to know what is nature of state. So nature of state is sovereign, socialist, secular, democratic, republic. This is nature of state. And once we have this nature of state, then what we want to give to Indian citizen, so it is ideals before the constitution, that is justice, liberty, equality, fraternity. We want to give Indian justice, liberty, equality, fraternity on this particular date of adoption and implementation. So when we read preamble, we come to know four important things. First one is source of authority, nature of state, ideals before the constitution, and date of adoption of the constitution. We'll go for these things one by one. First, our preamble starts with the people, with the wording we the people of India. Another thing, we have taken this lining we the people of India from American Constitution. It shows that authority to frame the constitution to the Constituent Assembly has been given by people of India. So in case of India, sovereignty, that is supreme authority, lies in the hands of people of India. So what is source of authority for Indian Constitution? People of India are the source of authority for Indian Constitution. People are the source of authority. Then second, what is nature of state? We want to have sovereign, socialist, secular, democratic, republic. This sequence is also important. Remember this sequence: sovereign, socialist, secular, democratic, republic. It is important for all objective examination that we want to make India into a sovereign, socialist, secular, democratic, republic. We'll try to understand all these things word by word. See, sovereign, in simple term, we can define the word sovereign in 2 to 3 ways. First, simple definition. What is meaning of sovereign? A country will be called as a sovereign when it has right to decide, right to determination. When a country is not influenced by any kind of external or internal interferences, then that country will be called as a sovereign nation. So any nation which is not influenced by, interfered by internal or external factors, it is called as a sovereign nation. What is another meaning? It means since India is a sovereign nation, it has right to acquire any territory, it has right to give away any territory. It is called as a sovereignty. No interference, right to acquire a territory, give away any kind of territory. On 15th of August 1947, India became a dominion of British. Indian Independence Act of 1947. Remember this is a British Parliament's Act. Indian Independence Act of 1947 created two dominions. One was Dominion of India, second was Dominion of Pakistan. These two dominions had majority rights in their own hand, but still they were not sovereign nation, they were not independent nation. On 26th of January 1950, India became complete sovereign nation. 15th of August 1947, we were Dominion of British Parliament. On 26th of January 1950, India became complete sovereign nation. All rights came in our own hand. India became complete sovereign nation. Right. So this we have discussed. Now when a question came that when India joined Commonwealth of Nation, is it going to compromise our sovereignty? To which Pandit Nehru replied in a witty manner, joining Commonwealth of Nation it is an agreement by free will which can be terminated by free will. We are joining it by our own choice, which we can terminate by our own choice. So we are joining it by our own choice, which we can go by our own choice also. So first, sovereign nation. We want to make India into a sovereign nation. Second, we want to make India into a socialist nation. Socialist nation. The word is added by 42nd Amendment Act of 1976, which is known as a mini constitution. What is simplest definition of socialism? Listen very carefully. When means of resources, production, property, wealth, all these things are given in the hands of people, it is known as a socialism. When we make an attempt to distribute wealth, power, resources, production, money to all people equally, it is known as a socialism. So we want to give to the socialism. The word socialist is not used anywhere in the constitution except preamble. It is the only place where the word socialist has been added by 42nd Amendment Act. Now, also it is not defined anywhere in the constitution. As we discussed, we are not going to define certain words so that we can interpret those words progressively. DPSP talk about socio-economic democracy. Then two types of socialism is there. One is state socialism, which is also known as Marxist socialism. What is state socialism? Means of production should be owned by people. Means of production should be owned by society. But on behalf of society, these things should be in the hands of government. It is known as state socialism. On behalf of people, these things should be in the hands of state. It is known as a state socialism, like China, Soviet Russia, North Korea, and many other East European nations. State socialism. Second one is democratic socialism, which is also known as Gandhian socialism. Democratic socialism, when means of productions are owned by people and government act as a facilitator. Here remember, government act as a facilitator to give these means of productions in the hands of people. It is known as a democratic socialism or Gandhian socialism. State socialism, state is the owner on behalf of people. Democratic socialism, people are the owner and state act as a facilitator, mediator to make people owner. So it is democratic socialism, it is Gandhian socialism. Democratic socialism, it is Gandhian socialism. Clear this thing? So Indian socialism is a mix of Gandhian and Marxian socialism, which is inclined towards Gandhian socialism. It is inclined towards Gandhian socialism. Clear this thing? So democratic socialism, second one is state socialism. We are mix of both these things, inclined towards Gandhian socialism. Clear this thing? So this is simple thing. Article 39B and Article 39C. Article 39B says means of production should be equally distributed among the people. That's why we have land reforms. It talks about distributive justice. Article 39C says prevention of concentration of wealth in the hands of few people. Wealth should not get concentrated in the hands of few people. Wealth should be equally distributed among equally. That's why we have progressive taxation in India. In progressive taxation, we tax rich people more. We collect revenue, and that particular revenue is again used amongst all the people. So it is 39C, which is called as a progressive taxation. So it is redistributive justice. 39B, 39C. Clear this thing? So we are studying what is socialism, state socialism, Gandhian socialism, 39B, 39C, DPSP, that is Directive Principles of State Policy. Then comes secularism. The word secularism is added by 42nd Amendment Act, which is famously known as a mini constitution. It is not defined anywhere in the constitution. We have seen positive secularism, we have seen negative secularism. Positive secularism, when state, that is government authority, treats all religions equally, it is known as positive secularism. In India, we have positive secularism. Second one is negative secularism, where state do not recognize people based on their religion. State first treats every person as a citizen and then comes their religion. It is a negative secularism. Negative secularism is a Western concept. Negative secularism is a Western concept, and most importantly, uh, basically, negative secularism is more advanced as compared to positive secularism. Negative secularism is more advanced as compared to positive secularism. And then, same point that we discussed in previous session, what are the provisions of the constitution which manifest secular character? So it is preamble, article 14, 15, 16, 25 to 30, and article 44. So these are the provisions of the constitution which manifest secular character of Indian constitution. So this is basic thing that we need to remember. Next is democracy. The word democracy came from Greek word demos, which means people, and kratia means rule. So rule of people, where people are sovereign. So basically, what is democracy? It is government of people, by people, for people, where popular sovereignty lies, where people are supreme to decide what is good, what is bad, what should be there, what should not be there for them. So it is a popular sovereignty. Democracy. Two types of democracy is there: direct democracy, indirect democracy. Direct democracy, when people are directly involved in decision making. Switzerland is one of the best example, but looking at the size of population of rest of the world, it is not possible to have direct democracy. Indirect democracy, when people are not directly involved, but people's involvement is being achieved through the representatives of the people elected by people, is known as indirect democracy. Like we have in simple term two types of democracy. So many types of democracies are there, but for our understanding, one is parliamentary democracy, which we have in India, Britain, Japan. Second is presidential democracy, which we have in America, France, and Sri Lanka, at all these places. Two important types of democracies. These are the few words. Please go through these words. Will not go into these words. Are important for match the pair. They could ask you a question on match the pair. It is given in the notes. It is not that important, but just go through these four words which are very, very essential. Indirect democracy that we have in India, it is also known as a elected representatives. It is also known as representative democracy. Mainly parliamentary democracy in India, presidential democracy, America, Sri Lanka, France. India, Britain, Japan. We have parliamentary democracy. They have presidential democracy. I am just skipping the part which is of no relevance. We'll go for more important part. India have representative parliamentary democracy. This is important thing. They could ask you a question in prelims like, which among the following features represent or reflects democratic nature of Indian polity? Which among the following features or which among the following options represents democratic character of Indian polity? So they are universal adult franchise, periodic elections, rule of law, which comes under Article 14, independent judiciary, absence of discrimination on certain grounds. All these things plus others, along with others, represents or manifest democratic character of Indian polity. All these things show that we have a democratic characters of Indian polity. Then we have two types of democracies in parliamentary democracy itself. One is monarchical democracy, second is republic democracy. Monarchical democracy, when head of the state is hereditary. When head of the state is hereditary, but they have democratic setup, it is known as a monarchical democracy. Second is republic democracy. When head of the state is elected, it is known as a republic democracy. In Britain, head of the state is queen. It is hereditary position. So in Britain, there is a monarchical democracy. In India, we have republic democracy. In India, head of the state is president of India, and he is always elected, not directly, indirectly, but he is always elected. So it is known as a republican democracy. It is famously known as a republican democracy. So basically, monarchical democracy, republican democracy. Monarchical democracy, when head of the state is always hereditary, it is known as a monarchical democracy. Head of the state is always elected, it is known as a republican democracy. Then comes republic. We have seen four nature of Indian state: sovereign, socialist, secular, democratic. Now we want to make India into a republic nation. We want to make India a republic country. So what is simplest definition of republic? Any country where topmost person is elected by people either directly or indirectly, it is known as a republic nation. When head of the state is always elected by people either directly or indirectly, it is known as a republic nation. In India, president is always elected by people. Now see, few minutes ago we have seen that in case of India or in case of any democracy, people are supreme, people are sovereign, people have right to determine. So when we think about the word republic, it has, one is explicit meaning, second is implicit meaning. Explicit meaning, which is definition. What is definition? When head of the state is elected by people, it is known as a republic. When head of the state is elected by people, it is known as republic. Second thing, since people have the right to choose, people can choose anyone. That is, topmost position is open for everyone. What it says? It says topmost position is open for everyone. So the word republic has two things. Head of the state is always elected by people, and second thing, it says topmost office is open for everyone. Remember, on 15th of August 1947, India got a dominion status, and on 26 January, India became a democratic republic country. These two meanings are very, very important. Now, what are objectives of the constitution? Till now we have seen what is the nature of state: sovereign, socialist, secular, democratic, republic. Now we'll try to understand what are the objectives before Indian constitution. So objectives before Indian constitution are justice, liberty, equality, fraternity. This sequence is also important. Justice, liberty, equality, fraternity. This sequence is very, very crucial for this particular thing. Again, I am telling you, we are not here to discuss Lakshmikant. We are here to revise Lakshmikant from the perspective of UPSC Prelims and your state pieces. So justice. Justice is a concept on ethics and law. Ethics, it means justice always try to search what is right, what is correct, what is just. Justice always try to search what is right, what is just, what is correct. That's why justice is a concept on ethics and law, which means that people behave in a way that is fair, that is just, that is equal, and it is balanced for everyone. We have taken this concept of justice from Russian Revolution 1917. I will star on this point, important. Justice has been taken from Russian Revolution, and we want how many types of justice? Social justice, political justice, economic justice is expected. Social, political, economic justice is expected. Social justice, will not go in details of these things, but which articles of the Indian Constitution talks about social justice? So basically, Article 15, 17, 23, 38, 43, they talks about social justice. I will star mark this point. 15, 17, 23, 38, 43. Which articles talks about economic justice? Article 38, 39, 40. Remember this article: 38, 39, 40. Political justice, Article 326. You can add Article 325 also. So Article 325, 326. So social justice, economic justice. Third one is political justice. Then comes liberty. Liberty, in simple term, liberty is absence of any kind of restraints, restriction, limitations. But remember this thing, liberty is not absolute. You do not have right to do whatever you want, whatever you wish, whatever you want to have. Liberty is about having reasonable restrictions when you are able to enjoy your life and personal liberty. So remember, we have taken liberty from French Revolution, justice from Russian Revolution, liberty from French Revolution. This is very important concept about liberty. Then comes equality. Equality, all people should be treated equally without any kind of privileges, absence of special privileges. No one will be given any kind of special treatment. Absence of special privileges is the key to equality. We are expecting three types of equality: civic equality, political equality, economic equality. Civic equality, 14, 15, 16, 17, 18. 5 articles are important. 14 to 18. Political equality, 325 and 326. And economic equality, article 39. So all these are important. 14, 15, 16, 17, 18. 325, 326. And here article 39. So we talk about these three: civic equality, political equality, economic equality. Fraternity. Fraternity, simple concept is there. Every person should have a feeling of brotherhood, maintaining dignity of the individual. If I am not having a feeling of brotherhood, there are certain sections who are discriminating me, who are not giving equal treatment to me as per my life, race, color, gender, sex, then I will have a feeling of undignified life, and it will compromise unity, integrity of India. So basically, word fraternity signifies maintaining dignity of the individual. It leads to, this is very important, maintaining dignity of the individual leads to upholding unity and integrity of the nation. We are expecting fraternity under article 51 capital A, that is fundamental duties. How many fundamental duties are there? Right now we have 11 fundamental duties. 11 fundamental duties. Simple concept is there. 42nd Amendment Act added 10 fundamental duties. 86th Amendment Act added 11th fundamental duty. And then comes article 1. Then comes article 1. So it is basic. You have to remember. Opinions about preamble, which are very, very essential for the match the pair. I gave you just only keywords. These things are very, very essential. First one, it is called as Horoscope Kundali by K.M. Munshi. It is called as Yardstick by Pandit Thakurdas Bhargava. Every word is important. What we thought, dreamed, Alladi Krishna Swami Iyer. It is iCard of the Constitution, Nani Palkhiwala. Best Draft, M.V. Piley. Stunning Principles of Welfare State, J.B. Kripalani. Keynote by Ernest Barker. More Than Declaration of American Independence, M. Hidayatullah. All these, just go through the word by word. Very important. Just go by word. No need to go in details of these things. Just these words are very, very essential. Then comes question, is preamble a part of the Indian Constitution? When this question came in front of Supreme Court in Birwari Union case of 1960, at that time Supreme Court had narrowly interpreted the thing, and in Birwari Union case of 1960, Supreme Court said preamble is not a part of the Indian Constitution. It said preamble is not a part of the Indian Constitution. But in Keshwananda Bharti case, Supreme Court reviewed its earlier decision. Basically, Supreme Court is a court of review. It can review its earlier decision by higher number of judicial bench. So in Keshwananda Bharti case, it said preamble is the part of Indian Constitution. And in LIC of India case, it said preamble is an integral part of the Indian Constitution. So Birwari Union case, preamble is not a part of Indian Constitution, but in Keshwananda Bharti case of 1973 and LIC of India case of 1995, preamble is part of Indian Constitution. So we can amend the preamble. This is very clear. Can preamble be amended? Since in Keshwananda Bharti case, it can be said very clearly that preamble is part of Indian Constitution. So we can amend the preamble. But what care should be taken? We must take this care while amending the Constitution. While amending the Constitution, you should not violate basic structure of Indian Constitution. While amending the Constitution, you should not violate basic structure of the Indian Constitution. Now, important conclusion. These three lines are very, very essential. We'll just go with first, third one line. Preamble is non-justiciable part of the Indian Constitution. So this is important. Preamble is non-justiciable part of Indian Constitution. It means if anything is not implemented over here, you do not have right to go to the court. So preamble is non-justiciable part of the Indian Constitution. Second thing, preamble is not a source of power to make laws. It means you can make laws based on preamble, but you cannot claim that since this law is made on preamble, so you cannot challenge this in the court. I am saying based on preamble you can make laws. There is no restriction on making laws. But after making law, if that law is violative of constitution or law or legal thing, you cannot say, I made this law based on preamble, so don't nullify it, don't invalidate it. No, it is not the case. So preamble is not a source of power to make arbitrary laws. Also, preamble is not a prohibition upon the legislative power of the parliament. Means if you want to make a justified law, you want to make a very good law, and someone is objecting that this is not given in the preamble, so cancel this law. It is not. Preamble is also not an arbitrary prohibition upon law making power. I repeat this line once again. Preamble is not a source of power to make arbitrary laws. You can make laws which are legal, verified, justified, free and fair. Also, preamble is not a prohibition upon the legislative power of the parliament, right? So this is the case. So we'll stop here. We'll be completing this entire series as early as possible. Keep watching on YouTube and have a good day. Study well and have a great time. Thank you.